At this time, we're going to head into session one, which is Disability Law in Medicine, presented by Mary J. Goodwin Okendo. Mary is a disability civil rights attorney at Joanne Simon, PC, and an adjunct professor of law at Fordham University School of Law. In her practice, she advocates for individuals with disability who have experienced discrimination in school or the workplace and/or require accommodations on high-stakes examinations. Mary is a member of the New York State Bar Association and an appointed member of the organization's Committee on Disability Rights. She has developed continuing legal education coursework and has a special interest in publications. She's also a member of the Disability Rights Bar Association, the Association on Higher Education and Disability, or AHED, and has served on the executive board of the New York Urban League Young Professionals and the National Urban League Young Professionals Programs Committee. Mary, thank you for joining us, and we're excited to hear your presentation.
Thank you so much. I'm just delighted to be here, and I thank you, Peter, I thank Zainub, and I thank Stanford for inviting me. I feel that this is a very necessary program in order to increase access and equality of opportunity for individuals with disabilities, and also to show others how to be allies. You know, so much of what I see in my profession with schools and testing companies and others, it isn't always malice. Sometimes it's just ignorance, not knowing what the rules are or not knowing how to help. So, you gave a wonderful introduction about my professional background, but I'd like to share a little bit about my personal background. So my interest in disability law was first sparked when I was a very small child and my younger brother in preschool was diagnosed with multiple learning disabilities. He was also diagnosed as being on the spectrum, and there were all of these other confusing diagnoses that were assigned. And the evaluators, some of the educators, they put limits on what they believed my brother was capable of achieving in life. So I noticed even at that very early age, how important it was for a student like that, a child like that, to have an advocate. And that advocate was my mother. And she fought so hard for my brother to make sure that he received the proper assessments, then that he received the proper supports and accommodations. And I saw just how instrumental that was, because he was able to achieve things that students that he was originally placed with or grouped with were not. And I think a large part of that was advocacy. So very early on, I knew that I also wanted to speak on behalf of those who either couldn't or didn't know how. In addition to my early experience with my brother, I personally identify as an individual with a disability. I have fibromyalgia, I have chronic fatigue that causes a lot of physical discomfort, pain on a regular basis. It's considered a chronic condition. And sometimes when I'm flaring really badly, it can cause issues with cognition, right? So sometimes my recall will be a little bit delayed, or I'll just have what's called brain fog. And that's not something that's unique to fibromyalgia or chronic fatigue, but So I was diagnosed with that at age 19. Though I believe I'd been dealing with it a few years prior, the reason why things came to a head at age 19 is because when I was in college, I was faced with academic demands that I never encountered before. Fast forward a few years to law school, it was the same thing. So at each level of schooling, I found that I needed to adjust how I approached my academic requirements, how I approached my daily routine. So as I said, I was diagnosed at 19, but I didn't receive accommodations until law school, because I didn't know that accommodations existed for people like me. So that's why I believe programs like this are so important. You know, people can become, quote unquote, disabled at any age. Not everyone is diagnosed in early childhood. Many people, have chronic conditions that are diagnosed much later in life. Many people experience new injuries or illnesses that cause them to become uh, diagnosed and disabled later in life. So, what I hope everyone will get out of my program, my session, is okay, what are the rights of individuals with disabilities? How do you identify an individual with a disability? And what are the responsibilities of society so that we can tackle these issues and increase inclusivity? So what you'll see on this slide is a general outline of the career path of a doctor. So when does it all begin? Right? Everyone thinks it begins with the MCAT, medical school, the licensing examinations, internship, residency, fellowship, employment, and so on. What isn't apparent, however, is that the path, it actually starts much earlier when we're talking about disability, especially if someone has a disability that began in early childhood or adolescence. Your path to medical school, unfortunately, is often shaped by your experiences early on, the support you receive, the diagnoses that you receive, and so on. So these are the three categories of disability civil rights laws, right? At the top, we have the Americans with Disabilities Act. It's a federal law. It was first passed in 1990. So think about how long, as a society, we went without having a civil rights law like this. It was passed in 1990, and then it was amended in 2008. And then we have Section 504 of the Rehabilitation Act of 1973. This act only applies to recipients of federal financial assistance. So if there's no federal affiliation, it will fall under the Americans with Disabilities Act. So that's why the ADA was so important. Just think of all of the institutions and organizations, employers, all aspects of everyday living that were excluded from Section 504. And then lastly, well, not last, I would just say last but not least, we have the state and local laws. So, in New York, that's the New York Human Rights Law, the New York State Human Rights Law, New York City Human Rights Law. California has similar laws, and so do many other states. What you should know about this hierarchy is that the ADA is essentially the floor for rights, right? The state and local laws grant you more. They can't grant you less than the ADA. So under the, well, let me backtrack for a second, just to clarify. Who is subject to the law, right? Now, we're not talking about individuals with disabilities just yet, but who is subject to the law, right? Employers are subject to the disability laws. Schools are subject to the disability laws. Testing companies, licensing organizations, restaurants, venues, those are called places of public accommodations. They're all subject to the disability civil rights laws. And if someone is able to prove that they are an individual with a disability, then that covered entity is prohibited from discriminating, right? Discriminating includes not granting accommodations. It includes retaliation, hostility, exclusion. the only ways that an organization that is covered by the ADA can exempt itself, so to speak, from providing those accommodations is if what someone is requesting is an undue hardship, meaning, they just don't have the resources to implement the requested accommodations. If what the person is requesting would be a fundamental alteration. So sometimes employees or students, for example, will request accommodations that will completely change the essential functions of the job, or change the meaningfulness of the school's degree. That could count as a fundamental alteration. And then lastly, there's something called direct threat. And that's where, the accommodation can't be granted because it would result in harm to other employees, harm to the public, or harm to the individual themselves. So now that we've covered that, background on, which entities are subject to the ADA, let's get into who is protected by the disability civil rights laws. So under the ADA, the term disability means a physical or mental impairment that substantially limits one or more major life activities or bodily functions of such individual. That's commonly referred to as prong 1. Prong 2 is a record of such an impairment. And prong 3 is being regarded as having such an impairment. So for this last prong, being regarded as, that really isn't a favorite for attorneys or individuals who are seeking accommodations, because the law says that people who are simply regarded as having an impairment are not entitled to accommodations. They're not entitled to accommodations, but they can be discriminated against on the basis of disability, so they're protected in that regard. With regard to prong 2, a record of such an impairment, that's, let's say, someone has a condition or had a condition that's no longer an issue for them at all, right? So a medical condition that's resolved completely. This prong protects those individuals from being discriminated against, though it's unclear if the law allows for them to receive accommodations. This is why prong 1, physical or mental impairment that substantially limits one or more major life activities or bodily functions, that's why that is the most popular, because it's the most straightforward, and it really involves people who are dealing with a condition that impacts them in the here and now, and that it's a condition that can be easily documented. So just to elaborate on what major life activities mean in prong 1 of the definition of an individual with a disability, major life activities include things like caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, working, and test taking. I know that I just said a mouthful, but this list is non-exhaustive. One thing that you should know is that there are many impairments that implicate more than one major life activity. So if you are an individual with a disability, or you're a clinician, you're a provider for an individual with disability, and you have to document this person's impairment, you should be sure to include every single major life activity that is impacted. In addition to major life activities, if someone has a substantial limitation in a major bodily function, they're also able to demonstrate disability. So major bodily functions include functions of the immune system, normal cell growth, digestive, the digestive system, the bowels, the bladder, neurological system, brain, respiratory, circulatory, endocrine, and reproductive functions. Again, the above list is non-exhaustive, and it's possible for someone to have a condition or conditions that impact more than one major bodily function. So that should always be represented in the documentation that is created to substantiate the disability. When you're thinking of disability, you should think of them in terms of 3 categories, but only for a practical purpose. And that's because most schools and testing companies and licensing organizations divide up impairments into these 3 categories. So we have physical is one of the categories, cognitive is another of the categories, and psychological/psychiatric is a 3rd category. I think physical impairments, especially for this audience, are very easily defined. Cognitive impairments include things like learning disabilities, processing disorders. Let's say someone has post-concussion disorder, that could count as a cognitive disorder as well, given the major life activities that are implicated. For psychological, conditions like ADHD, schizophrenia, anxiety, depression, bipolar disorder, those are all commonly placed into that category. And as far as documenting these conditions, physical conditions need very, very current documentation. And typically, you need to provide documentation that's no more than 6 months to 1 year old. With regard to cognitive conditions or psychological conditions, it depends on the nature of that particular impairment. So something like a learning disability, if it was diagnosed in childhood, or even if it was first diagnosed in adulthood, that's something that is permanent. It's not going to go away. How it manifests may go away, but it's not going to go away. So if you have a comprehensive evaluation report that is, let's say 3 years old, you could consider that current. However, for psychiatric conditions like anxiety and depression or bipolar disorder, given that these chronic conditions are, they're not static, they're subject to change, sometimes the presentation will be worse or more limiting. For that reason, schools, testing companies, employers, they like to see more current documentation. Before I move on from the general categories of disabilities, I would just like to let everyone know that an impairment doesn't have to be permanent to count as a disability under the disability civil rights laws, right? If you can establish prong 1, you're good. If someone has a temporary impairment, if it is sufficiently severe, it can also be established under prong 1 of the ADA and be covered and afford an individual with disability the protections of the law. So, but it depends on what the condition is. So everything is on a case-by-case basis. Everything that I'm saying right now, there are no hard and fast application rules. Everything is on a case-by-case basis. So just keep that in mind. Now, how does one document their disabilities? First and foremost, letters and reports from qualified clinicians. A qualified clinician doesn't have to be a physician. can be a psychologist, can be a licensed counselor, but it has to be someone who is licensed, someone who has the professional experience and education, and someone who has, the competencies required to make the diagnosis and to recommend accommodations. With regard to letters, one thing that I see in practice very often is that physicians, while well-intentioned, will often be, very stingy with their words. And that's not helpful for individuals with disabilities, especially if this letter is to establish that they have an impairment, if this letter is to support or make a specific recommendation for accommodations. Practically speaking, the letters should, of course, be dated. They should include, a brief summary of the clinician's professional experience and qualifications. Alternatively, you can attach a CV, but I still recommend the summary. It should list every single diagnosis that the individual is seeking to disclose to the school or the testing company or the employer, include the diagnostic code, whether that's the ICD or the DSM will depend on the specific impairment that's being diagnosed and or the qualifications of the clinician. It should explain the specific diagnostic criteria that the individual satisfied. So it's not sufficient to just say, for example, this person was diagnosed with fever of unknown origin and they should receive accommodations. You need to explain how the impairment was evaluated, whether that includes scans or labs, physical evaluation, and so on. The letter should also get into prognosis, and that's because one of the defenses that the other side may try to use is that, these conditions are temporary. Or how do we know that this hasn't resolved? How do we know that it won't resolve soon? So make sure that prognosis is included, and also make sure that you include a specific recommendation for accommodations. Now, I know a lot of clinicians will say, well, how am I supposed to know what works? If you don't have a starting point, ask your patient. Ask your patient what they're going through, what they find works. And, sometimes you may need to do a little bit of brainstorming, troubleshooting. But if your letter does not include a specific recommendation for accommodations, it will not be very valuable to your patient. With regard to reports, when I'm speaking of reports, I'm speaking of psychoeducational evaluation reports, neuropsychological evaluation reports. The issue with this that I see in practice is that a lot of the tests and the measures that schools and testing companies and licensing entities like to see, those tests are not covered by insurance. Or if they are, only a few are, but then you don't have a comprehensive evaluation report. Under the law, ideally you shouldn't be required to undergo all of these very expensive assessments. But in practice, that's often what it takes to establish disability, to provide multiple objective and well-validated data from objective and well-validated measures, and so on. Proof of prior accommodations. This is great if you've received prior accommodations. If you were evaluated earlier on and you have a paper trail, that's wonderful. But many people don't have a paper trail. And that's because either, they were afraid to ask for accommodations, they didn't know that accommodations existed, or for many people, they received informal accommodations, or they utilized compensatory strategies and aids that help them manage. That's a form of self-accommodation. And under the law, that counts. So if you are someone who does not have a paper trail to support a current request for accommodations, but you fall into any of the categories that I just described, it would then be helpful to submit other supporting documentation. And I know I'm skipping academic records, apologies for that, but it would then be helpful for you to provide other supporting documentation from individuals who are very familiar with your functional limitations and can attest to them. So that could be family members, parents, your spouse, your siblings. It could be professors, guidance counselors. It can even be employers if you have that kind of relationship with your employer. That kind of information is helpful. Now, do schools and testing companies and employers always ask for these things right away or at all? No. That's because it's not their job necessarily to make it easy for you to get the accommodations. So even though they don't ask for it, if you have that kind of documentation that you can provide to substantiate your request, you should absolutely provide it. And then academic records. I'm skipping back to the third column on the PowerPoint, academic records. Many people who have not received accommodations, they're able to look back at their academic records and make connections that then back up what they claim they've experienced. So let's take, for example, someone who wasn't diagnosed with a learning disability or anxiety until medical school. Their academic records may show that either they had poor grades, or if they're already in medical school and they're just being diagnosed, right? It may show that they perform better in some classes than others, right? So classes that had primarily essay assessments or lab assessments, or that had examinations that were relatively brief or tested material that had been gone over ad nauseum, that they've been able to manage and do well in those classes. It may also show that on standardized exams, there was a disconnect between what they were able to demonstrate in school versus on a standardized exam where there's a very controlled environment. You're unable to self-accommodate, you're unable to receive informal accommodations, and so on. For other people, let's say those who experience brain trauma, looking at academic records is helpful, but in the opposite way, right? You want to show that before you experienced this trauma, you didn't have any issues. And then afterwards, now you're having issues with concentration, cognition, and so on. You want to draw a line in the sand with regard to functioning. So academic records, as you can see, help both kinds of applicants or both categories of individuals with disabilities. And if you don't have it, you don't have it, but look for it if you can. Academic records don't have to just be transcripts or score reports. You can go back to former professors, former teachers, counselors, and if they recall your difficulties, a letter from them is a perfectly fine substitute for an academic record of that sort. Now, standardized exam accommodations, when we're talking about physicians, we're talking about the MCAT, we're talking about the USMLE, we're talking about the COMLEX and the specialty boards. Unfortunately, what I see in practice is that the accommodations that someone receives for the MCAT are often the same accommodations that the NBME will want to grant. Sometimes they'll grant less. So it isn't a guarantee, but essentially, if you received less accommodations than you need for the MCAT or no accommodations at all, it will be difficult, though not impossible, for you to secure USMLE accommodations. And since the Step 2 CS has been eliminated, I won't go into that, but for specialty board examinations, sometimes the oral examinations can be problematic, whereas someone was properly accommodated for the standardized games, the ones to test the knowledge, right? So the reason why that happens is because a lot of these entities are used to things being cookie cutter. So if they only provide accommodations for learning disabilities or anxiety, ADHD, and they're used to only doing it for most people for the knowledge examinations, it's kind of difficult for them to make the connections as to why some of those people may need accommodations for the practical examinations. This is another reason why it's important for the supporting documentation to be comprehensive. So, not just in a personal statement, but also in the evaluation reports and the letters from the doctors. They need to explain, they need to foresee, if at all possible, all of the accommodations that may be needed as someone proceeds along their medical education and career, just because constantly going back and forth can be logistically challenging. And also it gives the school or the testing company or the employer an opportunity to say, well, if you did need that, why wasn't it included in the documentation that you previously provided for these other things? So with regard to medical school, there is three categories that I'd like to just cover: discrimination, pre and post admission, and accommodations. So what does discrimination pre-admission look like? Pre-admission discrimination means, not even accepting an interview or an application from someone who has readily apparent disability, or someone that has, decided to self-disclose their disability. That's not allowed. Not making the interview itself accessible is a type of discrimination. So if someone needs a translator, if someone needs to go to a different building that's accessible, let's say they have a mobility impairment, that's also discrimination. Schools are not allowed to ask people before they are accepted whether they have a disability. They're just not allowed to do that. The one exception may be if, they have a history of discrimination or something like that, and a federal agency or the federal government is asking them to make things right, then it may be acceptable for them to do that. Post-admission discrimination includes the denial of accommodations. It also includes the hostility, right? Refusal to allow the student with the disability to enjoy all of the benefits and privileges of the program. That's post-admission discrimination. And with regard to accommodations, I've kind of gotten into this in the prior sections that I've discussed, but if they are not providing the modifications needed for the individual to compete on a level playing field, that is discriminatory, right? The accommodations don't have to necessarily be the student's preferred accommodations, but they do have to be effective. Simply offering a modification doesn't mean that you're accommodating someone. An example of that would be, let's say someone needs extended time and they need access to a reader. If you're just providing extended time, you're not accommodating them. If the person needs 100% extended time and you're only granting 50%, you're not accommodating them. It doesn't matter if the school has never offered these accommodations to anyone else before, because there has to be an individualized assessment. So again, to avoid liability, schools should really work with students and their treatment providers to, ask all necessary questions and make sure that they're providing those supports and modifications that will allow not only equal access to examinations, but equal access to lectures and courses and so on. With regard to rotations, sometimes people need adjustments in the timing, right? Due to various conditions like, circadian rhythm disorder, sleep apnea, things that may make it difficult for people to wake up early. Those are ways to accommodate that. Also, sometimes people just need additional time between patients to write their notes, or additional time at the end of the day. That's an accommodation that for some conditions might be appropriate. And another accommodation would be additional guidance. Some people need to ask clarifying questions. Some people need certain tasks broken down a bit more. Depending on the condition, that may be an appropriate accommodation. But unfortunately, it's one that's often met with resistance, because a lot of schools tend to think that, or not a lot, but many schools tend to think that if someone needs that, they're not competent. But it's not that they're not competent, it's just that they need things presented in an alternative format in order to demonstrate their competencies. With regard to internship, residency, and employment, one thing to keep in mind is that internships and residency has been found by some courts to fall under both education and employment. So just keep that in mind when we discuss in a few moments the different ways to enforce your civil rights. Pre-employment discrimination includes requiring an examination, a physical examination or a psychological examination. That is not allowed. It is, however, allowed after an offer of employment is made. And that's if all employees for that particular position, or all applicants for that particular position, are required to undergo that assessment. Another type of pre-employment discrimination is like, let's say an employer requests a credit report, and the credit report shows medical expenses. That is not necessarily permissible under the ADA. So strategically, employers should tell the credit bureaus to not provide that kind of information. With regard to accommodations, many of the accommodations that I just described for medical school might be appropriate for employment as well. Some other things to consider include restructuring of the position, reassignment to an available position, and emphasis on available, because employers do not have to create a brand new position for someone with an impairment. And, lastly, again, going into physical and psychological examinations after, someone is already hired. This is sometimes necessary to demonstrate that someone is fit for their position. So there, just to clarify, pre-offer physical and psychological examinations are prohibited. Post-offer, physical and psychological examinations are allowed. And physical and psychological examinations are allowed once someone has already been employed for some time, just to demonstrate that they're still fit for the position. So if someone's civil rights have been denied, there are a couple of ways to go about enforcing them or attempting to enforce them, because unfortunately, there are no guarantees. There are 3 federal agencies: the US Department of Education, that's appropriate for schools; the US Department of Justice, that's appropriate for standardized testing companies, and also schools that aren't covered by the Department of Education because they do not receive federal funds. And then for employment, there's the EEOC, the Equal Employment Opportunity Commission. For each of these agencies, it's very important for you to know that you have a responsibility to file your complaint within 180 days of the act that you believe to be discriminatory, whether that's a denial of accommodation, retaliation. It has to be within 180 days. For employment and others, it may be longer, depending on if your state has a similar agency, then it extends to 300 days, but still go by 180 days per act of discrimination to make sure you're preserving your rights. Unfortunately, while federal agency complaints are free, they take quite a bit of time. So it's not a great option for a lot of people. They have 6 months to review your case and render a decision. That's a long time. And that's for the EEOC. And for the Department of Justice and the Department of Education, their complaint reviews and decisions can take much longer. Same thing for some state and local agencies. And this is why attorneys, whether private practice or nonprofit, are often the best option for a lot of people, right? So nonprofit attorney, of course, is free, but they have limited resources. Private practice attorneys cost money, but they're able to assist you better with or assist you much more quickly and more efficiently oftentimes. So I know that I've said a lot and I've gone a little bit over time for our schedule. So Peter, I'll turn it to you.
Can you go ahead and unshare your screen? Great. Thank you, Mary. That was extremely informative and interesting talk. We have some really good questions from the audience that I would like to ask you. The first one is, what do you do when the person who is the obstacle or barrier or denier of reasonable accommodations is also the ADA coordinator for the educational institution?
In a situation like that, you include them in a complaint that you either file with the U.S. Department of Education's Office for Civil Rights, or you bring the matter to an attorney, and they will include that person. In a situation like that, I can understand how that can be very intimidating to someone with a disability who's in need of accommodations. And it happens, right? Just because they hold that position, that doesn't mean that they're necessarily free of bias and can't discriminate.
The next question, why does it continue to seem like disability law is trying to put out fires rather than advance change? And even the fires it puts out are often only a tiny portion. It seems like disability law actually shores up a flawed system.
Well, I definitely could agree with that. If you look at the legislative history of the disability civil rights laws, unfortunately, the private sector, businesses, and schools, they've been very opposed. So the disability civil rights laws can be considered a compromise of sorts, which defeats the purpose of civil rights, you know? You shouldn't have to compromise your civil rights.
So I have another question. Do most people have to sue or litigate to assert their rights?
So in our practice, no, the majority of the results that we're able to achieve, whether it's with the licensing boards or schools, we do so through negotiation, right? Internal appeals and working with them directly. So the answer to that would be no, most people don't have to sue. Unfortunately, a lot of the people who are unable to resolve their situation without suing are unable to do so due to lack of resources. So that's another issue.
What about if someone is concerned about their privacy and their reputation? Can they sue or litigate anonymously?
So in past years, courts were reluctant to allow that. They felt that the defendant had a right to know their accuser. And in certain situations, the public had a right, they had a vested right to know who's bringing this case. However, in recent years, we've been able, our firm specifically, we've been able to sue under pseudonym. So like, let's say we were suing on your behalf, it would be, you know, PP. Or if it's me, like MJGO, that's again, another compromise. Because if someone really wanted to do digging, they could figure out who you are by, you know, cross-referencing the initials with the facts in the complaint. But it's still better than suing with your full name. Also, I just like to add that if you do file a complaint with one of the federal agencies that I mentioned, your name is not disclosed without your consent, right? So of course the respondent, so the school or the employer, they have to know who you are. That information isn't disclosed to the public without your consent, and then they can also take steps to protect your identity if necessary.
So when I talk to people who have been clearly discriminated against, a common theme that I have seen is that often they are already down a pathway, and they don't think about you know, making a complaint to the DOJ or hiring an attorney until a series of bad steps has already happened. And to me, it seems like hard to know if you're being discriminated against when to turn to the law. You know, the original title of this talk is "I Fought the Law and No One Won," which, you know, and I was, in my mind, I was thinking we would teach people how to negotiate the system without involving a lawyer. But, you know, lately it's become more clear to me that maybe we're not involving lawyers early enough in this process. What do you think the best timing is?
You know, it really depends. A lot of people have had success, for example, coming to our firm before they apply for MCAT accommodations, before they apply for SAT accommodations, before they apply to medical school. And they ask, you know, are there any issues that I should be aware of? How strong is my documentation? I'm concerned about X, Y, and Z. What are your thoughts on that? That is pretty this kind of preventive approach is helpful because you're doing a lot of the work ahead of time. So you're avoiding some of the issues with documentation. You're able to anticipate some of the challenges that you'll face from an administration or a testing board. So I think, you know, at least an accommodation earlier than not would be helpful. Additionally, with regard to preserving your rights, because that's very important, especially if someone doesn't want to retain an attorney and they'd like to avail themselves of the federal enforcement agencies, it's better to reach out when there isn't a problem, even though you think there may be or you're not sure. It's better to reach out and have them say, okay, well, this is a non-issue, than to let it go on and on and then, you're passing statutes of limitations, and, you're, like you said, falling further into this hole, and there's just so much to overcome.
Yeah, because you try to work within the system at first, right? You
That's
as
what
an
a
in,
lot of people, yeah. People are, unfortunately, I find that a lot of people with disabilities can be very apologetic about having a disability, about inconveniencing others. They feel guilty for needing accommodations and supports. And, you know, I can tell everyone, don't feel guilty, right? These are your rights. You have a right to have equal access. You're capable. You're all of these things, but it's easier said than done. Especially when, like you said, there can sometimes, like you said in the prior question, what if the ADA coordinator is treating me with hostility? What if the disability services coordinator is treating me with hostility? Those are all deterrents. But I hope that with programs like this one that you put together, that people will feel empowered to not only speak up for themselves, but speak up for others. There are a lot of people who come to me after saying, I didn't know that I had a right to these things, but I spoke to someone else who received accommodations and told me about the law or told me about their experiences. So we all have a responsibility, I think, to share our knowledge and our experiences to empower others.
Yeah, the apologetic thing really resonates. You just feel so grateful to have a job and to get any accommodation that you are afraid to push for more or push for what you actually need.
Mhm.
You'll only take
Oh,
it so far.
that reminds me of something else that I see very often with medical school specifically.
Mhm.
I often see medical schools counsel their students to ask for fewer accommodations on licensing examinations in the hopes that it'll make them think that you're not being greedy and that they'll approve the accommodation. When really that's not how they work. You can ask for half of what you need and they'll give you a quarter or nothing. So always ask for what you need.
Um, One thing that also has come up in my conversations with people is this issue of institutions or medical boards using an illness or a disability against the person. For example, I talked to someone who had a complaint made against them for a bad outcome that happened to a patient and had nothing to do with the disability. His disability wasn't even disclosed. But then, he confided in somebody about this complaint and shared that he had cancer and was undergoing chemotherapy. And then that person, started Googling the type of chemotherapy that he was on and found that there were case reports of cognitive effects, and
Mhm.
then turned the system against the person and made their disability into like a competency or a performance issue. And I've heard this time and time again where they use patient safety or professionalism or you know these sorts of things to as a weapon against the individual.
Yeah, it's really terrible when that happens, really disheartening. And I think it goes back to the direct threat defense or posture that a lot of entities will take, especially in medicine. There's this, oh, we have to protect the public from incompetent doctors, which is, of course, true. But why the spotlight on individuals with disabilities whose disabilities are not impacting their ability to practice ethically and competently? So, unfortunately, in a situation like that, the person would either have to file an administrative complaint with the EEOC. You said this was their employer, right? With the EEOC, and the EEOC could, if they find that there's discrimination, or even if they can mediate early on. So that's always an option. That's why it's better to go to them sooner than later. But even if they don't, they can issue a right to sue letter, and then you could take it from there, or they can sue on your behalf. You would have to fight that. Absolutely have to fight that, because when, and this is anecdotal experience, but from what I've seen, especially in the medical profession, when your colleagues turn against you, there's like this kind of bullying that can go on where they will force you out of your job, or they'll intimidate you. And that kind of hostility, that kind of treatment, even if they don't fire you and you quit on your own, that's constructive dismissal, and that's a type of discrimination that's prohibited. So absolutely fight that.
Yeah, I mean, when the patient safety boards or the licensing agencies, seems like they often jump to the disability as the cause of any sort of performance issue or incident that occurs. They're just really quick to turn it, oh, it must be because of their disability that this bad thing happened.
Mm-hmm. Mm-hmm.
Do you have any experience in people being sent to like cognitive or neuropsychiatric testing for like mental competency, or going to being sent to these places where they do in-depth examinations of your fitness for duty?
More experience with the former. So, a good majority of our clients undergo these neuropsychological or psychological evaluations, even if their main concern is a physical impairment or a physiological impairment, a disease. And that's because if possible, we'd like to present data that shows how they're impacted with regard to memory, concentration, focus, and things like that. With regard to the second situation, yes, we've encountered people like that. Sometimes it is permissible. Very often it's permissible, but that requires a deeper level of assessment than other types of cases. So in a situation like that, we would consult with an expert who administers these kinds of evaluations to compare what the the licensing boards or the credentialing boards physician or psychologist found versus what our person found, and then take it from there.
One last question. This is about what options are available to a student when the accommodations department has told them that the accommodations are a fundamental alteration. And can you talk about what a fundamental alteration really is?
Yes. So one clear-cut example of a fundamental alteration in medical school is permission to skip rotations, right? to not do that for whatever reason. There's a quite a few cases where, when I say case, I mean case law, where an individual with disabilities requested accommodations on the licensing examinations, right, which have to be completed typically within the first 2 years of your medical education. That was denied. So they were unable to pass the exam, but the school's rules state that, well, you're unable to go to the hospital to get this experience until you pass step 1, right? Or until you pass step 2 CK. In a situation like that, the school is not required to change its rule that they're requiring their students to have that have demonstrated those competencies on the licensing exam before they move on to the next step of their education. However, in a situation where the school is arguing that there's a fundamental alteration, get them to explain how and get it in writing. Send an email. Don't have conversations with people. And that's something else that I see. These meetings, face-to-face meetings that people have, and the telephone conversations, that's fine. But what is that in court? That's just, hearsay. You can't really prove it. So always follow up these meetings and these calls with emails or requests from them in writing so that they can articulate what the fundamental alteration is. Because sometimes they'll say it's a fundamental alteration, but they don't even know how it is. And if they're unable to demonstrate that, then you can push back. You can file a complaint with the Department of Education, or you can retain an attorney.
Well, I could talk to you all day about this, and I'm sure our audience could also listen all day. But I'm just thank you very much, Mary, for that very insightful presentation. We are now going to take a 10-minute break, and we will see you back at 9:30 a.m. for our second session, which will be a panel discussion of doctors with physical and mental health disabilities. So thanks.